Hi, my name is Vlad Genshu, and I am a personal injury litigation and trial attorney. I don't use that term lightly, trial attorney. I have tried 10 civil jury trials, 9 of which have gone all the way to verdict. I have tried 2 civil bench trials, and I have tried about 3 or 4 criminal trials, bench and jury. So I want to talk about civil jury trials in Los Angeles County. We talked a little bit in the earlier video about a final status conference, how it's really the second to last appearance in the mandatory, in the personal injury master calendar hub court that was put together in Los Angeles County in the prior decade in the 2010s and has been dismantled as of October 15, 2022, because LA County and the entire state now has more funding in order to put together local community courts. So we went from big courts, uh, these master calendar courts, which were basically administrative courts, in order to put together put together the tracking of the lawsuit, see if they could settle. 98% of trials settle, and then after we got more funding, we were able to put together the court system. Went back to the local level, and now we have community courts. But that really hasn't impacted the trials yet, because those cases have the cases that have gone to the community courts have only been filed from October 15th, 2022 on. And basically, there have been no trials yet on the local level from locally filed cases after October 15th, 2022. So let's talk about what happens to a case, a jury trial, a personal injury jury trial, from the time that you've passed, both sides, plaintiff and defense, have passed the final status conference. So that's done, and now you are going to the trial call. You are still in downtown Spring Street master calendar department, which means you still don't know where your jury trial is going to. When you go to the trial call, which is usually 10 to 14 days after the final status conference, it's usually 2 weeks after the final status conference, provided that you passed the final status conference, it will be 2 weeks after. If you failed the final status conference can be continued to the trial date, at which point you'll basically have the FSC and the trial call at the same time, or maybe you'll have the FSC, the final status conference, about 3 or 4 days before the trial call. I call it a trial call because obviously the trial does not happen in that department. As I said in the prior video, there's about 7,000 to 8,000 cases in these departments, these master calendar personal injury hub departments. So there's no way logistically they can try any case there. So the trial call is basically where both parties now have to physically appear in person. At the final status conference, it is encouraged, like at the vast majority of appearances and court appearances now in LA County, and I presume in the entire state, that the parties with counsel appear telephonically or through video. In LA, we have something that's free of charge. It's called LA Court Connect. It used to cost money early on in the pandemic. It was like $20, and they lowered it, and now it's free. And you could still use it, and you're actually very much encouraged to use it. Counsel are encouraged to log on to it. You have to log on to it no earlier than 2 weeks before, and no later than 2 hours before the hearing. So if you have a hearing on Monday, you should get your thing by Sunday night. You can log in at any time as long as it's not 2 hours before. So you should do that for the final status conference. You could appear, through video. You could appear through phone. You could frankly appear through your home. I know we're talking about LA here. Orange County uses a different system. San Diego uses a different system. Those systems require video, so you can't, be brushing your teeth for LA County and put yourself on mute while your case is being called while you brush your teeth. In Orange County, you have to show up with the video open, so you can't be driving down the freeway. You have to pull over. Otherwise, it's a little bit more formal in other counties. I'm not putting down LA County. I think LA County's got the best system because, frankly, you can do a lot of things in a very short period of time. You can make 2 or 3 appearances with LA County at the same time. So, but the final status conference you could do through the phone in LA County. The trial call, you cannot. You have to show up in person. The clients do not have to show up in person for the trial call. Trial counsel, who's going to be trying the case, do. The adjusters don't have to show up for the defense, whatever, vice president of claims, the actual client, if it's a non-insurance case. But, for a mandatory settlement conference, which is not the purposes of this video, the attorney has to show in person and has to have the ability to get on the phone with counsel, with their client to settle the case. At the trial call, the attorneys show up in person, and they have to have their exhibit books. So when we talk about getting ready for trial, we really have 2 binders. One is an exhibit book, and the other one is a trial readiness binder. When we talk about putting this together, we're talking about 10 books. 5 trial readiness binders, 5 exhibit books. The trial readiness binders is what would have been electronically served to the department for the final status conference. Whatever it would have been, DEPT, 32 SSC at lacourt.org. Whatever the email is for that Spring Street Department Personal Injury Hub Court, you send that 10 days out. They have it again for the final status conference. Not to belabor the point, but they have the trial briefs, they have the motions eliminated, the exhibit list, the exhibit, the witness list, joint and contested jury instructions, the list of the actual jury instructions, special verdict. All of that is divided. The pleadings, meaning the lawsuit, the complaint, the summons, the answer, any cross complaints, all that stuff is sent for the final status conference, provided that those were done in by the rules of the personal injury general standing order rules. There's the last one I think would have been 2022. As long as you met those things, you're going to the trial call. What do you bring at the trial call? You should bring, again, 1 copy. Well, the way I usually do it is the defense attorney would usually bring the 5 copies of the exhibit book. The defense attorney, he or she, has their exhibits marked out. So let's just say the plaintiff's exhibits are 1 to 100. The defense exhibits would be 200 and or whatever, 1,000 to whatever, 5,000. So exhibit 1-0001 is basically plaintiff's exhibit 1, page 1. I bring 5 copies of my exhibits. The defense counsel already has 5 copies of their exhibits, hole punched and paginated. You have to have that. And you have to bring in something resembling, this, so you can sticker them. All this sounds ridiculously mundane and just something that you teach something in high school. But people don't go to trial in civil courtrooms because of this. I walked in on a civil jury trial once that was a quadriplegic trial. It's a really unfortunate situation for the plaintiff in the sense that the plaintiff was quadriplegic. But I had the good fortune of trying it for 14 days. It was in front of Judge Randy Rhodes. He just recently retired. He'd been there since 1997 until 2023. And I won't forget what Judge Rhodes said. Again, big case against the city of LA and bird rides, potential tens of millions if it had gone 100% against them. Really tough counsel on both sides. Obviously arguing and litigating the case, dealing with a catastrophic case. Judge Rhodes, I think, summarizes why this needs to be done right in a civil case. He says, gentlemen, I think you guys are confused. Remember, Judge Rhodes has been a judge since 1997, did criminal cases, civil cases, did everything. He says, I think you gentlemen are confused. I think you think this is a criminal trial where the judge will, at the end of the day, because the criminal defendant has rights, will put together the entire trial for counsel, get together the jury instructions, calcrims, everything, put it together. He says at the end of the day, this is a civil case, not a criminal, which means that somebody is asking for money and somebody doesn't want to pay money. So you guys have to put it all together. So when we talk about this, when we talk about page line, deposition, annotation, when we talk about all that, it's really because it's a totally different animal. Bird. In criminal, you got really strong constitutional rights not to go to jail or prison. And then you have civil, where you're basically asking for money. And that's, if you're going to ask for money, you're going to want your money or you're not going to want to pay money, then you have to put it together yourself. So all of that needs to be done appropriately according to the or you don't have as strong of a right to a jury trial in civil that you do in criminal. The judge will put the training wheels on and get it through, get you a jury trial and get you a verdict in criminal. They won't do that for you in civil. You have a right to a jury trial by the Constitution. It's not a speedy one, and it's not one where the judge fixes it for you if you can't, as in helps you out. Okay, so we talk about how you annotate the pages. You could, Plaintiff's Exhibit 1-001. You could write it out in pen. It doesn't have to be done like in federal court. You got to have it perfect, but take out a pen. 1-001, 1-002, okay, and that's how you put your exhibits together. Regarding the defense, they'll do the same thing, and that's your exhibit book. So you show up. I think you should show up at 8 o'clock. I think you show up a little bit early, depending on traffic. You go to the Spring Street courthouse, federal court. Used to be federal court, still a federal building, used by the state. You go in, you show them your ID, you go through security, you go up to the whatever floor, you bring, as a plaintiff's counsel, your 5 sets of hole-punched exhibits, whatever they are. Discovery responses, whatever, medical records, photos. They're hole-punched. They're already annotated. You wait for defense counsel to get there. Maybe he or she's already there. Whatever. They get there at some point. You open up the exhibit book, and then you go on one of the benches, and then you put in yours. And then ideally yours are already tabbed. Again, tabbed, hole punched, and annotated, written out, 1-002. So, except that's enough. And then when you get called in, they open the department at 8:30 on the dot. You take out your business card. You write out whatever number you are on the court calendar, number 3. Whatever it is. Smith versus Jones. Ramirez versus County of LA, City of LA. You go in, business card. Judge will call, the clerk will call the case, says, the judge would like to see one of your exhibit books and one of your trial readiness books. Now it's no longer just emailed, it's now a book. You give those 2 books to the court. You then wait. The court comes out, says, great news, you have passed the trial call. Both counsel then show up. They go to the tables, plaintiff table, defense table. There's no jury there because remember, we're a master calendar courtroom here. Is there parties ready for counsel for trial? Yes. Are the ready day to day for trial? Yes. Have all parties been subpoenaed or on call and ready? Yes. All witnesses ready? Yes. Are all the Doe defendants dismissed? Plaintiff? Yes. Any cross complaints? No. If there are, no. Everybody been sued and served? Yes. So basically questions so that the judge is ready to send you out for trial. Provided that all that's fine, which it always is. If you pass the book, the final status conference, the trial readiness, and the exhibit book, everything's gonna be fine. So are you gonna go to trial? Not necessarily. Why not? Because in Los Angeles, don't quote me on the exact number, but there's probably no more than 10 to 15 trial courtrooms available to try a civil jury trial. these kind of personal injury cases for a population of 12 million. So what really matters at that point is how many other courtrooms are in trial, how many cases, if any judge is on vacation, how many cases are already in trial, how many courtrooms are available, um, and where your case is in terms of how old it is. If you just somehow, you know, were able to, you know, get to trial really quickly, and you still have a really not very old case, you might not go to trial. That you might have to be kicked out for another month because there's other cases where that have a 5-year rule that might need to go to trial or they'll get dismissed, and you're not going to have priority. It's like being at the lunch counter, taking your number. You have a depending where your number is. So if you have a 2021 case and it's only been 18 months, but you just did everything fast, you guys got everything ready. You didn't sit on because you did everything right. But there's other people who, COVID, witnesses got sick, whatever. They're going to go first. So you might be ready for trial, and they might say, "I'm sorry, there's no departments ready. There's nothing ready. There's no of the departments available. You're going to have to come back a month." And I've had that. I've had that in bench trials. I've had that on jury trials. I mean, it also depends how long you expect your case to be. If it's a 2-day trial, it depends, right? Let's presume that they say there's a department available and they give you what's known as a first assignment. So we talked about how you start off in a personal injury hub court. So when we talk about hub court, you're in a master calendar court. So then the question is, well, my accident happened in Van Nuys. Where am I going to go to trial? Well, it depends on these assignments. It depends on the availability of court. So you're basically on a wheel, sort of, and where you're now going to be assigned a courtroom. And let's just say that you get assigned Long Beach, a certain department, judge so-and-so in Long Beach. And, what do? Well, you have the right to what's known as a 170.6, Code of Civil Procedure 170.6, a preemptory strike, where you basically can say, I want to strike, to not agree to this judge. Because remember, you didn't really have that judge. That strike is preserved until you get your first assignment. You could have used it in the hub, but what's the point? That judge isn't going to be your trial judge. So if you think Long Beach doesn't make sense, maybe the accident happened in Van Nuys, and you want a Van Nuys, jury because they understand that intersection. That's a common intersection. Maybe your client lives in Santa Clarita, and he or she doesn't want to drive Van Nuys every day. Maybe, if that's the case, you might want to, if you really like Long Beach, think it's a good judge, good jury pool, you might want to consider paying for their hotel. But let's just say for whatever reason, you just don't feel it with this judge and this jury pool, you can 170.6 them. Just do the affidavit, a declaration, sign it right there. You have 20 minutes. And there's an entire, I wouldn't call it a strategy, but there's, plaintiffs and defense, they try to poker game each other by, not turning it in early within the 20 minutes. You have 20 minutes to decide if you're going to stay or keep with that judge. Each side has the right to 170.6 a judge once. So you can't do it. Basically, each side gets one. So if both sides use it, the third assignment is going to be, the one you're going to go with. So if you use your 170.6 and you end up with a, the defendant, basically the defense gets to either pick the next judge or use their 170.6. And again, there's a strategy with that, which is if you don't like that assignment, you think it's a bad assignment, do you think it's, people aren't going to understand your case that well, or some people like to wait until 18 minutes or 19 minutes to see if the other side will exercise their strike, which will save you a strike for the next one. You don't know. You might actually get a worse assignment the second time. It's not a bad idea. It's done all the time. I was taught to do that. sometimes doesn't work. Usually both sides, usually people that the attorneys that try cases, they kind of know the reputation of the judges and all that. So you end up with the next assignment, let's just say, because you use your strike, your peremptory challenge as it's called, on the first assignment. And the next assignment's going to be whatever, Spring Street. And let's just say the defense goes with it, and that's where you go. Or the defense doesn't go with it. So there's a couple other things here, which are, again, I wouldn't call this is relatively, it's a chess game, which is, let's just say your client is itching to go to trial for whatever reason. They have a vacation coming up that they can't move. They love their case. Your witnesses have to go now. You have expert witnesses that are flying in from across the country. You need to go to trial within a month. You have to go to trial within a month. I mean, what do? Right? I mean, if you get a first assignment that says show up to department whatever in Van Nuys tomorrow at 10 a.m., are you really going to say no to that? Because if you do, what if the next assignment, and you say no to that, the next assignment says show up to Santa Monica in 2 weeks? You needed to finish your trial within a month. Now you burn 2 weeks. What if the defense burns that assignment? And it now says show up to Torrance in a month. What do? It's a chess game. You got to think about it. You got to think about how good of a judge am I going to get? Am I going to get a fair judge? Am I going to get a fair jury? Are my witnesses going to be ready? Or do I just have to go with it? I believe in my case, and we'll take what we can get. We'll just go to that. We'll go to that pool, that jury pool, and we'll just pick the best jury we can get. And that's it. So, it depends. For the most part, I've never had to deal with that in the sense that I've never had witnesses and, that have been, they had to do it within a week or something like that. But it's something to take into that could be advantageous or disadvantageous. So when you look at that situation, you have to consider that just because you're getting an assignment doesn't mean you're going tomorrow. The assignment can basically say, hi, see you in a week. And I've had cases where it says see you in a week and the department calls. And they say, listen, we can see you tomorrow. And I'm like, yeah, sure, I'll do it at trial. Plaintiffs usually are always more likely to go to trial because, plaintiff's counsel and plaintiff, and we don't see a dime until we settle or go to trial. So the defense counsel might say, no, not available. Sorry, because the assignment was for Monday, and we're not going to go on Thursday. So you need to take into account the calendar. Because just because you get a third assignment might mean, I'm sorry, we don't have any more courtrooms today. You guys blew through 2 assignments. We don't have a million assignments. So presume that you take your second assignment, or whichever assignment it says show up in a week, which is very reasonable and very likely. You then show up in a week to Spring Street, or Stanley Mosque, or Torrance, or Van Nuys, or Chatsworth, or Long Beach. And you will try the case there. So what happens when you show up? That's just a trial call. What happens when you show up to court? That's going to be the next episode.